there's going to be more big news, I believe, that comes out than XRP holders. And I think we're going to get some fairly positive news.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel.
There's no token out there in cryptocurrency world that has been more ready for some kind of positive news, as you know, Paul, than XRP holders. And I think we're going to get some fairly positive news. It may take several more months, but I think we're going to get there.
Where are we on the dates currently? What's next that happens from the SEC? And then what will that trigger for Ripple before we potentially get to a summary judgment?
Sure. Well, all the briefs are filed. We're going to talk about something that has just transpired. There was actually news that just came down a couple seconds ago on Library, and we'll talk about it. But basically, all the briefs are in. The final reply briefs for each side, Ripple and the SEC, were filed. They're redacted, and basically, it's before the judge. There's still some unsealing of exhibits and deposition testimony that the public may get to see. So there's still lots of things for the curious XRP holder. You may get to see, more of the Hinman deposition and get to read it. You'll get to see maybe the emails that are related to the Hinman speech. That's big news. So there's going to be more big news, I believe, that comes out that you're going to see all over crypto, Twitter, and YouTube. But as far as the legal substantive decision, that's before Judge Torres. And obviously we have the Christmas holiday and other holidays, the New Year's. And so I think we're probably looking at around the end of March as when we would actually see a decision. It could go into, all of April as well. But I'm hopeful that it'll be by the end of the first quarter is what I'm hoping.
Are they pretty much done with possibly responding or trying to launch a counter at that time? Is the case over, or what's our next step or next risk?
All right, well, let's look at possible outcomes, right? So let's take the first outcome possible is that the SEC gets an outright win. I know you want to start it with a positive, but that's the first negative result, right? Yeah. And then a second option is that Ripple gets a flat out victory. And then, of course, there's a third option where there's a partial summary judgment granted in part and denied in part. Wow. And that could be a split. And then finally, there's a fourth outcome that it's a split, but also a jury trial could necessarily be needed for certain issues. The only two issues that I foresee a jury trial where the judge could say this particular issue needs to be decided by a jury is if we get to the fair notice defense, right? Ripple even said in their papers, Paul, that the fair notice defense, whether or not Ripple received adequate and fair notice, that's a jury question for the jury to decide. Now, hopefully the judge doesn't get that far, right? Because hopefully she never rules on fair notice defense because it's an outright victory. So back to your question, though. Let's say there's either an outright Ripple win, or the judge says that Ripple offered an unregistered security in 2013, 2014, and fines them for that, but that today ongoing and future sales of XRP are not considered securities. Either one of those are a great victory. And so then the question is, what would the SEC appeal the decision? Would they then want to go to the Second Circuit? And I don't think they would, right? The interesting question, the most interesting question about all this, Paul, is what you're getting at, which is, okay, John, what happens on the ground? If Ripple wins, or they're held to only violate the law in some very early years, some very beginning sales, but today's XRPs and future XRP sales are not securities, what happens? Well,
Yep.
we would see some price appreciation, one would expect. And whether or not Coinbase, Crypto.com, Kraken,
Yep.
Binance US,
Get the relist.
the question is, what do they do? Do they relist? If the SEC doesn't appeal the decision, then the law of the land is Judge Torres, and you would think that they would relist, right? Especially in today's environment where you have the SEC and Gary Gensler saying, oh, there's so many tokens or securities. If you've got clarity on XRP and there is no appeal, and Judge Torres' decision that XRP is not a security, if that's the law of the land, then of course you would expect those exchanges with that kind of clarity to relist XRP. And so that's the good news, I think, if happens. I would doubt that the SEC would appeal a decision if they get a split win. The early sales are securities, but today's sales are not, because Ripple has a really good argument on appeal, and conservatives like the Supreme Court are very conservative, and they could go back and revisit Howey and put the SEC out of crypto completely. And at least with XRP, if they lose, they can turn around and say, hey, that's just XRP. And, facts and circumstance. You always hear Gary Gensler, regulators, utter those words, facts and circumstances. Facts, meaning each crypto is different. Was it an ICO? Was it not an ICO? What were the facts and circumstances surrounding the sales? And so I think that if that happens, it'll be good news for all of us who are XRP holders.
Wouldn't you think that this is still the case if Ripple, in fact, wins, that crypto communities unify and kind of understand this is a good thing for crypto in whole?
Yeah, I think you're right. We're in the same boat about trying to limit tribalism, and we want, a healthy ecosystem for many digital assets. And so, it's unfortunate, but that it happens, because we're really fighting, especially with this FTX collapse and all the fraud involved. And then you ducktail that on top of the Celsius and all the bankruptcies, and crypto has a big bullseye, right, on its forehead right now. You have the Sherrod Brown, who is the senator from Ohio. He is the chairman of the banking committee of the Senate. Literally is like the SEC should think about banning all crypto. I mean, you have the chairman of the chairman of the banking committee of the Senate uttering words like that. And so it's unfortunate, because we have to fight those people, right? We have to fight the overregulation. We have to fight people, the incumbents of the banking system, and all the people that want to hold crypto down instead of fighting ourselves. And so it's unfortunate, but I agree with you. I think that, a rising tide, right, lifts all boats. And I think that a victory in this Ripple case could unify all of us, because everybody loves winners, right? We all gravitate to the winning team. And so hopefully that happens. Even if there's dozens of those people, it still does not represent the entire, community. And so I've had ETH people get mad at me because of what I expose about the ETH, regulatory free pass and Hinman and all that. Even though I'm an ETH holder, they've attacked me, but I wouldn't indict the entire, ETH community just because a few of them don't like me. You know what I mean?
What do you think it was that was putting everybody on this December 15th date, that even some of the biggest crypto leaders out there were kind of penning a decision on this date? What was it that was happening that they thought would really kind of trigger that date?
Well, I think two things about that. One is, I think that Charles is a huge voice in crypto. I mean, he is a co-founder of Ethereum and the founder of Cardano. So when he speaks, it carries a lot of volume. But there was a meeting between the SEC, a preset meeting where they discussed potential settlements of cases. And there was just some speculation that if the case was going to settle, it would settle right around that time, because it was a specified date to discuss settlement. And there's no bigger case in crypto than the Ripple case. So it just built speculation that that's the day that it was going to happen. And I can't speak for Charles of who told him, but allegedly a reliable source that he thought, and he never said it was going to happen.
As far as the SEC and the CFTC, who do you think wins this battle on the control of crypto as a security or crypto as a commodity? What's your thought?
I think ultimately it's going to be the CFTC, but I think it's going to be a battle to get there, because I think that with FTX happening the way it did, you're having a lot of regulators are confusing regulation versus fraud. And there's not one bill that was proposed in the Congress or the Senate that would have stopped Sam Bankman-Fried from doing what he did. It's an old case of theft. When I was on Charles Payne's show early on before his arrest, I said, this is not a crypto problem, it's a criminal problem. And he could have, if someone's going to lie, steal, and cheat, they can do that whether or not you call these cryptos commodities or you call them securities. And so, unfortunately, when you have a crisis, you have people who react to that crisis, and they have a tendency to overreact. And so now I think there's going to be some especially on Democrats are pointing to the SEC, and the Republicans are pointing to the CFTC.
Sure. And
with the new Congress flipping, and you're going to have Patrick McHenry is now going to be the chairperson of the Financial Services Committee in the House with Warren Davidson and Tom Emmer. I think that they'll definitely be pushing it towards the CFTC.
We know that Library lost. It was kind of a different and a very swift moving, case. Why did that move so quickly to a resolve versus what we're seeing happening with Ripple?
Well, one, the main issue for Library is that, and people need to distinguish this, the Library opinion, that summary judgment, Library did not contest 2/3 of the Howey test. The Howey test of 3 factors. Investment and common enterprise was not contested. In the Ripple case, it is contested. There were many depositions in the Ripple case where there were less depositions in the Library case, and it's just a matter of
faster moving.
Yes, and no doubt that Library, the SEC had there's different case law in the First Circuit. That's where New Hampshire is. That's different in the Second Circuit, where Southern District of New York, where the Ripple case is. And it's more favorable New Hampshire. And you had an old school judge. He's a very good judge. But he's good. His hands are tied by the appellate case that he was relying on, which is this SG case. But something new has happened, and we just got word literally as you were coming on air. So the Library case, the SEC won its summary judgment. But you go from there to a remedies phase, Paul. And you have to then determine, okay, the SEC won. So now what remedies is the SEC seeking, and what will the judge agree to? And what that means is, will there be a permanent injunction that Library and Library's executives can never be involved in crypto? How big of the fine will there be? Will there be disgorgement of profits? Things of that nature. And Library went to the judge in the SEC and said, we're dissolving Library, the entity. We will burn all pre-mined LBC credits, tokens, and we'll pay a fine, and we don't have any money, and all the profits that we did earn, that we put into the business, and so the business is gone. And Library, to his credit, Jeremy Kauffman spoke up and said, Judge, now that we're dissolving and burning the pre-mined, there's no argument that secondary token holders could ever need to rely on us. So the SEC should give clarity to secondary purchasers and also users who never even bought XRP. And the SEC objected to that.
Yeah.
But the SEC objected to Library's proposal. The judge was sympathetic to that proposal. And so what we did is ICANN, which filed an amicus brief in the Ripple case, and I, on behalf of Naomi Brockwell, who has a channel on Odyssey, on the library blockchain,
right.
and she's accumulated a couple 100,000 credits of LBC credits. We asked permission of the judge to allow us to file an amicus brief so that he can clarify this issue. And just as we were coming on air, the judge granted the motion. So now I can formally file that amicus brief. And all it's asking is saying, look, Judge, secondary token holders that use the platform, the token itself's not a security. Same thing I argued with XRP. And two, your decision was limited to just the way library sold LBC.
Okay.
It has no impact. And I point out to the judge that Naomi Brockwell, and she deserves credit for allowing us to use her name and her example, she's never sold or bought a library credit. Never. She just makes them as tips and things like that on the library platform, and she stakes them and it gets more views to her videos. And so I point out to the judge that she doesn't even satisfy the first prong of Howie, which is an investment. She didn't buy it, right? She just, someone gave it to her, and she has no expectation. In fact, when she first accumulated library credits, Paul, she didn't even know that they were traded for 2 pennies or 5 pennies each. She didn't know they had a monetary value. So this is a very monumental, important issue because the SEC wants this like blanket kind of approach that tokens themselves are securities. So if the judge is open to it and he limits his decision to just library, it will have a positive impact. You know, if he's able to say, listen, my decision has nothing to do with secondary market sales of this token.
Yeah.
And so that's the real issue.
This would be interesting to see how this plays out. Once the amicus brief is filed, what would be the next result? The judge is going to try to make a resolution, or is there something that the SEC would do to kind of push back on that? Because this could set a precedent, could it not?
No. Well, sure, it could. And the thing about it is it's still one judge, one case, and it can always be distinguished. But as I point out, a clarification is better than no clarification, right? If it's vague, it's vague. It can be argued. But there are also XRP holders who acquire XRP and they use it on the ledger to transform money. There's other businesses on it. So there's lots of similarities in all of these cases. But you make a great point about how it could affect the gaming industry and affect NFTs in the future. And so the SEC has basically a week to file a reply to our amicus briefs, and then the judge will carve out a ruling, and he's just going to decide. For example, he could say that disgorgement is not an issue because there's case law from the Supreme Court that says if you used all the money that you raised into the business and then the business is gone, there's no point in can't get blood from a rock, right? There's no point in disgorgement because there's no benefit to the person. He could issue a fine to library. You raised several $100,000, so I think $50,000 fine or $100,000 fine. And if he does, what we're asking is if he does enjoin library or the library CEO or any executives, that he specifies that injunction is only applicable to those specific individuals and not the token itself. And, they should be treated more like a commodity. And hopefully there could be some kind of subcommittee at the CFTC that's, dedicated to digital assets that maybe reports back to the full commissioners of the CFTC. But I'm hopeful, but I'll tell you, Paul, it's why this Ripple and library and all that we've been talking about is so important, because the Ripple case is really going to be de facto regulation for the at least for the first half of the year, right? If not the entire year. But you see a lot of Democrats now who are not happy with Gary Gensler. So I think a key is if we can get Gary out of there somehow, then maybe we could bridge this.